constitutional element of power. Strong gavel there.
Good afternoon, and thank you for joining us. My name is Brenda Carter. I'm a state representative from Michigan and vice chair of the NCORE Budget Committee. I am going to moderate this general session. We have a great panel of speakers with us today to discuss a very important and interesting topic centering on the Supreme Court's recent repeal of what's known as the Chevron doctrine and whether it will mean the rebirth of state regulation. The panel will go into this with much more detail, but generally speaking, the Chevron doctrine arose out of a 1984 Supreme Court case, and it was interpreted to mean if Congress has not directly addressed the question at the center of a dispute, a court was required to uphold an executive agency's interpretation of statute as long as it was considered reasonable. Put another way, when federal agency regulations are challenged in federal court as an improper interpretation of statutes, courts have traditionally deferred to agency interpretation unless they find the interpretation is arbitrary or consistent with statute. Throughout the years, this doctrine was controversial, as opponents have argued that policy should not be made by government officials who are not elected or not accountable to the public in the same ways as members of Congress are. And that delegation of regulatory authority to federal agencies undermines legislative powers. Regardless of one's position on the doctrine being overturned, the court's ruling will have significant implications for numerous policy areas, including insurance and particularly health care. This session will be a great opportunity to hear from experts as to what impacts the court's decisions will be on policymakers should be aware of going forward as they draft laws and interact with their colleagues in the executive branch. Joining us today to discuss these issues are Craig Green of Temple University School of Law, Jack Bierman of Boston University School of Law, Michelle Long of KFF, and Greg Serio, former superintendent of New York Department of Financial Services. To learn more about these speakers, you can view their bios in the program and also on the app. I urge you all to reach out to them afterwards to learn more about them and about these important issues. In terms of format, we will hold all questions until the panelists are finished speaking. So let's get started. We'll hear first from Craig. Craig, please go ahead.
Thank you so much. What a great opportunity to be here. I am an admin person and not an insurance person, with apologies that way. I think Loper Bright is, we just heard it was the most important thing to happen in Washington, but I certainly think it's the most important administrative law case in 80 years. Now, that might be a little like saying Nike is the best tasting running shoe since the invention of rubber, that French dip is the best sandwich at Arby's. But it goes back to a really, really old question, and that's the way I want to frame it, is if you think of a non-administrative law statute, you can imagine a legislator and a court. And the legislature makes it, and the courts interpret it, and you could imagine a legal system where the legislatures would communicate the meaning to courts, but that's not the one we have. So you have Congress on the one side, federal courts on the other, the courts do the interpreting, and that's the end. Administrative statutes are different. Congress creates an agency and creates courts, sort of like a triangle. And they don't often specify how the court should review agencies. And they created this agency for the purpose of having the agency play a leading role in the implementation of that statute they just passed. It's immediately more complicated. It's been more complicated since the 1800s, is the first time these questions of administrative deference came up. Skipping forward, the 1930s and 40s, as administrative law grew, so too did this question of deference. And in 1984, as was referenced, Ronald Reagan comes into office to transform the American government. He'd love to change the Clean Air Act or repeal it, but he lacks the votes. I don't know if it sounds familiar. So instead of being able to change the statute, he puts in place a number of conservative, pro-business bureaucrats, including Ann Gorsuch, Neil Gorsuch's mother, as the EPA administrator. And she very quickly proposed a regulation to reinterpret the word source in the Clean Air Act in a very pro-business, not pro-environmental a direction that had been different from how the agency had interpreted before and different from how courts had interpreted that word source before. She was a new administration with new policies and new ideas and got down to work exactly that way. The Supreme Court, as was mentioned, basically said that's fine because the EPA is in charge of implementing the Clean Air Act. It's an ambiguity. What does source mean? Congress could have said what source means, but they didn't say. And so any reasonable interpretation that the experts in that area might have are close enough for government work, as they say. The Chevron doctrine stands for maybe three big principles: specialization, expertise, and flexibility. And you can capture all of those from its very beginnings in 1984, if not before. Now, if you didn't know the history, you would think that maybe everyone would support Chevron when your person was in the office, and you would maybe oppose Chevron deference when your opponents were. But that's not how the history went, actually. Conservatives for a really long time were early adopters of Chevron, which is not so surprising given that it came out of the Reagan administration. Former Justice Scalia was a passionate defender from the start to the finish. Thomas Roberts, the leader of the Federalist Society, AAI, they all supported Chevron deference until they stopped supporting it. And this actually happened at a very relatively narrow window of time, right around 2013 to 2015. It was a very interesting set of questions. I've spent a lot of time thinking about it. That's the past. The present is Loper-Bright overturned Chevron after about 10 years of warm-up. So for about 10 years, the Supreme Court and justices and various conservatives have been agitating for it. And the consequences are very clear of what overturning Chevron means. It means shifting power away from agencies. Of course it means that. Agencies had been interpreting these statutory ambiguities, and now they are not. Also a shift away from Congress. Congress now doesn't have the power in the particular way to create agencies with that kind of specialization, expertise, flexibility. And all of the power that is shifted away insofar as those increments of power shift away from agencies, shift away from Congress, they shift power to the courts. Stops specialization, stops expertise, stops flexibility, change one to the next. I'm supposed to say precedents, our judicial precedents are carved into the rock and they do not change. That's what I'm supposed to say. At least maybe compared to agency changes, maybe that's true. And so what it does, as was mentioned, is it increases the burdens on Congress. It means maybe less federal governmental power as there's less things to agree upon. But of course, from this point of view, that's not a bad thing. That's not a glitch, it's a feature. The idea of making it harder for the federal government to do things is actually better, as was mentioned at the lunch, increasing pressure on state governments and increasing licenses for private power. I think that's got to be the right way to think about it. The Supreme Court in Loper-Bright says there's only one way to interpret a statute, and we judges are uniquely qualified to do it, and we will do it. And I think that's a dramatic, would be more dramatic if it hadn't been coming for 10 years. But of course, Chevron, my administrative law professor, would have sworn in his immortal soul that it would never be overturned. A lot of things have happened, maybe that he would have made that kind of bad bet on. Now, there are two ways, literally, of reading the opinion. One is to interpret it as a little deal. Maybe Loper-Bright is a little deal. There are parts of the opinion, as they struggle in various ways with prior case law, where the Chief Justice Roberts says, well, we're not doing deference anymore. There's no deference. But there is, quote, respect, quote, due respect, quote, great respect, and, quote, very great respect. So, maybe it's just a matter of shifting around and changing the terminology and everything's going to be basically the same. That is one possibility as a textualist reading the opinion. That is possible. But that is not where my money is on. Second is maybe it's a big deal. Maybe it's a big deal where there are large ranges of huge, expansive ranges of federal governance involving interpretation of vague statutory provisions, including for the public interest, including what is reasonable, including what is appropriate. These are all areas where, under the Chevron regime, if not before, agencies could claim specialization. They do this all the time, expertise because they know things other people don't, and flexibility. I work for the federal government in the Department of Justice, and I was trained to think that when the president came into power, whether I voted for him or not, you got to steer the wagon to the right, steer the wagon to the left. And that's how it went, That's what Reagan believed when he got elected in 1980. That's what I was trained to believe during the time I was in the federal government. It's not my policies, it's the president's policies. And there's a whole bunch of flex in the system where it can be steered to the left or steered to the right. I think overturning Chevron in combination with other administrative law decisions is more like taking the wheels off the wagon, not just steering it to the left, not just steering it to the right, but actually inserting real obstacles to federal governance as it had been imagined in an earlier regime. The future. So when thinking about how Loper-Bright will be applied in federal courts, I think the words that I would use to describe it are directional chaos. There are words, new words, that are going to have to be worked out by lawyers. What does respect mean? What does very great respect mean? What does any of this mean? What's the new standard for a delegation of authority to a federal agency? What does Congress have to write in its new checking the homework kind of way? What level of specificity has to be done in order to accomplish the things that Congress might want to accomplish? You could look at the major questions doctrine, independent agencies, agency adjudications, Jarkesi from this past year. There are all signs of signals of the direction. Even if some of the details are unclear, even if some of the words could be fought over, I think it is, as have been called, an anti-administrativist Supreme Court. I think that the overturning of Chevron fits very well with that broader direction. You can tell which direction the precedent's going to be, even though you may not be able to identify exactly where it'll start or stop. Some of the earliest cases that have applied Loper-Bright, there's one out of the Seventh Circuit and one out of the Fifth Circuit, which I'm happy to talk about. But the Seventh Circuit opinion, I think, looks almost like they just dropped a footnote and said, by the way, we read Loper-Bright. And that's basically the only change, like nothing really changed. Of course, they've been getting warning shots, don't rely on Chevron, for 10 years. You know what I mean? People get that message with variety of, again, it would be very surprising if it weren't so slow coming. The Fifth Circuit didn't take that approach in one of its cases. It really did reform a lot of the ways that it approached statutory interpretation. It disregarded decades of agency practice regarding tipped workers, what counts as a tipped worker, disagreed with at least 3 other courts of appeals that had decided different parts of that issue. I mean, it was like they just woken up Rip Van Winkle style, like, well, all of a sudden we now decide tipped workers means this and everybody get used to it. And that actually is one vision of Loper-Bright. That's exactly what Loper-Bright thought courts should be doing, starting again, doing their judge thing, and not worrying about what anybody else thinks about it. So I think in that sense it is a big deal. The big deal interpretation, right now, this moment, there are judges, of course, a high percentage of judges appointed by the earlier presidency, Donald Trump, and a large number of judges appointed by other presidents. But I think over the next 5 to 10 years, as the number of Trump-appointed judges increases from a set of judges and legal organizations and judicial ideologies and constitutional philosophies that match a very consistent, since 2013, 2015 approach, you should see the big deal interpretation of Loper-Bright winning out, I think, over the next 5 to 10 years. Alongside with sort of the Musk Ramaswamy 5-day office, Schedule F, there are a lot of things that are being done, I think, by the executive branch. And the last thing that I think I would say is you might think, as Scalia thought, that Chevron would be good for whoever's in power. But I think that the question for the new administration would be, to what extent are they going to be able to push their deregulatory, predominantly deregulatory projects and be approved by the Supreme Court. They're not going to be able to change a lot of the statutes they want to change. Can they use the bureaucracy the way Reagan used the bureaucracy? And I think that's going to be the big question. I think state and private power on the way up. And the last thing I would say in the spirit of state regulation is, I'm from the Commonwealth of Pennsylvania, and when I talked to them about some of the government lawyers there, they said, oh, well, we have a Chevron statute. State law actually says that you can look to agency interpretations to interpret the law. They said, so we're good. We have no problems at all. And I think, whatever, what am I to argue with Pennsylvania's good lawyers? But on the other hand, I think that one thing to bear in mind is not all ideas stay put in one place. Not all ideas stay put in one place. And from this day forward, every law student in the United States will be taught that Chevron is wrong and Loper-Bright is right. And so every state system that has something that looks more like Chevron and less like Loper-Bright will seem like more of an anomaly. And a lot of the political forces, I think, that have operated in the federal environment and the federal sphere, they may not stay put in one place. So I think the things that I would think about for state law is, I think, of course, different states, some states do have what we could call at the moment Chevron statutes that might, but I think also both at the federal and state level, thoughts about what agencies really need or deserve should have as a matter of policy. That kind of deference that had been applicable under Chevron is no longer applicable under Loper-Bright. There may be an effort to try to, not across the board, but maybe for particular agencies in particular contexts, try to be sensitive to enacting things to accomplish through statutory law what I think would have been taken away by the Supreme Court at the federal level. Thanks very much.
Okay. Thank you, Craig. And now we'll hear from Jack Bierman.
we have my slides available, I hope. I sent them in. There we go. Beautiful. Good. Okay, those are my slides. So I assume this little green button is what I push to go to the next slide. It's really an honor to be here to speak to a group full of legislators. I rarely get to speak to anyone that can make a difference in the world, and I just want to lobby for my favorite pet peeve as a statute, which is I would love to see a uniform law come out of this body outlawing anyone backing into a parking space in a mall parking lot or a grocery store parking lot, because then they have to put their carriage between the cars and scratch up my car. Anyway, that's one of my little pet peeves. Anyway, so but now I'm going to disagree with Chevron being a big deal. I disagree with the lunchtime speaker, and I disagree with my colleague, because before the Loper-Bright decision was made, the Supreme Court had already decided that agencies didn't have any power to do anything important if the statute wasn't clear, and that's the major questions doctrine. So Chevron only applied to unimportant things. So the only real question is whether it's important or unimportant, because if it's important and it's not clear in the statute, the agency can't do it anyway. And this is part of the effort to deconstruct the administrative state. This was supposed to be a slide of Steve Bannon on deconstructing the administrative state, but I couldn't find a good picture of him, so I got the next best thing for who's involved in deconstructing the administrative state right now, which is the 6 of the 9 people you see in front of you. I don't know how this is really going to affect state legislators. I have to say, I think maybe if there's less federal regulation, that'll leave more room for state regulation, assuming that they're being honest about wanting to leave things to the states. But then we saw this morning on the very interesting panel about ERISA preemption that very often the federal government is greedy and wants to stop the states from acting either, because the interest groups that put pressure on the federal government get the federal government's ear to the detriment of state policymaking authority. But anyway, so I've been saying for years that Chevron was a bad decision. This is an article from 2010, and I had been saying it before that I thought Chevron was a failure, not because of anything in principle wrong with it, but because it became just a complete mess with so many complications and so many sub-issues. You could write, as I wrote in this essay, I wrote probably 60 or 70 pages on all the unresolved issues under Chevron, and there were many more that other people wrote about. In fact, I had a paper, I don't know how the law review let me get away with it, but this was the title of the paper. It was a paper about the meaning of Chevron. And I had a subtitle, which is Chevron is a Rorschach test ink blot, because it really meant whatever the beholder, it was in the eyes of the beholder. Sort of like when I umpire a baseball game, and for some reason the offensive team always thinks that the runner was safe, and the defensive team always thinks the runner was out. But it was just a bad decision. And the one thing is, another reason why I don't think it really had much of an effect is if you count up the cases, what you'll see is that the conservatives and liberals basically deferred when they liked the agency decision. That is, I counted the cases, and Justice Scalia, who we've heard was the big champion of Chevron, well, he deferred the least of any Supreme Court justice to agency views. And I just counted the cases. Basically, the liberals deferred when the agency made liberal decisions, and the conservatives deferred when the agencies made conservative decisions. And as the courts of appeals have gotten more politically polarized, that started to replicate at the Court of Appeals level also, which basically means that Chevron didn't really decide the outcome of any cases. It just was part of the way that they wrote the opinion. So I'm going to go back. I had my slides a little bit out of order. So we all know what the Chevron doctrine was, which was this doctrine that said that if a statute was clear, you apply that understanding, and if the statute was silent or ambiguous on the issue, you deferred to that, a reasonable agency interpretation. But what became very important early on was that at step one, about determining whether the statute was clear, the statute didn't actually have to explicitly or expressly determine the issue. Basically, you applied the traditional tools of statutory construction. And since I can't do anything with my hands that involves tools except play with children, I use the traditional tools of statutory construction. For me, are all inflatable. But under the traditional tools of statutory interpretation, basically, for at least the last 25 years under Chevron, courts were doing exactly what they did before Chevron, which was decide what they thought the best meaning of the statute was under the traditional tools. So again, overruling Chevron was just, all it really would do was save billable hours in cases being litigated, because people don't have to argue about how and why Chevron applies or doesn't apply in the particular case. Now, I want to go back a little bit to the origins of Chevron to put this in context, because I think the historical context does help us see where the court is going now. So in 1980, there was a case about a pretty aggressive OSHA regulation of benzene to save workers who worked with benzene from cancer. And the Supreme Court threw out the regulation. And in the course of throwing it out, the Supreme Court said that if the government were correct that the statute made such a sweeping delegation of legislative power, it might be unconstitutional under the non-delegation doctrine. And in this opinion, in this decision, Justice Rehnquist wrote a concurring opinion where he said the important thing is that we make sure Congress makes the important choices of social policy, not the courts and not the agencies. And so that was what the court was concerned about. So then in 1984 we got Chevron, and as we learned, the reason we got Chevron was because the conservatives on the court had to figure out how to defer to these pretty extreme reinterpretations of all these regulatory statutes when the Reagan administration came in on a deregulation platform. And the Democrats hated it and the Republicans loved it. Or at least the Democrats were skeptical. But they said it was contrary to separation of powers. The Republicans said, well, elections should matter. Agencies are more accountable than the federal courts, so we should defer to the agencies rather than have us as federal judges impose our views. And things started to change really in the middle of the Obama administration, where Democrats started loving it because it seemed to enable effective regulations, and Republicans hated it and said all of a sudden that it was contrary to separation of powers and allowed unaccountable bureaucrats to thwart the will of Congress, exactly what the Democrats were saying 20 years earlier. But in fact, it really did neither, because the Supreme Court really wasn't applying it. It did die a slow death, but my argument has always been that it really didn't have much of an effect even while it was on the books, although the lower courts did seem to consider continue to apply it. And it was, so even though it was, to me, it was always unclear, the Republicans in Congress got very attentive to this. They passed bills repeatedly in the House called the Separation of Powers Restoration Act to overrule Chevron, but that law could never get through the Senate, so it died in the House. Now, but again, because Chevron didn't really apply in extraordinary cases, and because the traditional tools had to be applied before you got to the deference part of Chevron, in my view, it didn't really make much of a difference. And so the major questions doctrine, in my view, the creation of this new unprecedented thing called the major questions doctrine, which limits federal agencies' power to do anything important in emergencies like, for example, pandemics and climate change. Those decisions are much more important than anything you would ever say about Chevron. Now in Loper Bright, as we know, the court finally overruled Chevron, and it gave three sets of reasons. First, it said it was contrary to the Administrative Procedure Act, and on this I think they were right, because the Administrative Procedure Act says very clearly that the courts are supposed to decide all relevant questions of law and interpret constitutional and statutory provisions. So that, to me, that was, anytime you have a doctrine which is contrary to the governing statute, it's sort of doomed. They did mention the unworkability of the Chevron doctrine, which was my main problem with Chevron, because I do think deference as a matter of policy is a good idea, and it's proven itself to be a good idea. But they also expressed some constitutional doubts about Chevron. Now, one of the things they said was that the court characterized the APA as incorporating, and I'm quoting now from the Loper Bright opinion, a settled pre-APA understanding that deciding such questions of statutory meaning was exclusively a judicial function. Now, my recent paper, which I came out with after Loper Bright in the Cato Supreme Court review, annual Supreme Court review, shows this was false. It's not true at all. And in particular, there were two well-known decisions issued in 1944, the Hearst Publications decision and the Skidmore decision, which held that reviewing courts owed at least some deference to agencies' conclusions. Now, Craig used the word respect or great respect, but the lower courts already are using the word deference when they talk about Skidmore. The word respect doesn't mean much to them because they understand deference. And so they're already, even the Fifth Circuit, in another opinion which I'll talk about, talks about Skidmore deference. And further, there was a pre-APA report by the Attorney General, the Attorney General's Commission on the Administrative Procedure Act, which was formed by President Roosevelt in 1949, which said that even on questions of law, independent judicial judgment seems not to be compelled. There was definitely not a settled practice before the APA of non-deferential review of agency decisions. Now, so the court's opinion also raised these constitutional problems with Chevron, but it didn't make a constitutional holding. And in my view, there's almost nothing to any sort of suggestion that there's it would be unconstitutional for courts to defer to agencies. They cite the Article 3, they cite the Federalist Papers, they cite Marbury versus Madison, but they don't actually cite the relevant part of Marbury versus Madison, where the Supreme Court, under Chief Justice Marshall, said, of course, when the federal government has discretion, courts cannot question it. And the predominant mode of judicial review of discretionary agency action up until the Administrative Procedure Act was passed was to defer, to not even review it. And the APA itself exempts certain kinds of review from judicial review. Now, I personally think that once the administrative state grew, we needed judicial review, we needed the judicial check, and that's why the APA has been such a great and enduring statute. But I don't think it has anything to do with the Constitution. But, you know, there's one thing for sure about our current Supreme Court, which is they can create a originalist basis for almost anything they want to do. Now, Justice Gorsuch wrote a concurrence, and Justice Gorsuch's concurrence should really be startling, I think, to people, because Justice Gorsuch basically said that we should not feel that we're bound to follow precedent. He basically says precedent really is only a clue, but it doesn't really bind us at all, because our job is to find the correct answer, not to defer to, not to blindly follow precedent of our predecessors here at the Supreme Court. And this is like a pre-modern version of what law is, where there's correct answers out there like a Platonic field, you know, Platonic ideas, where the better legal reasoning will discover it. And that's just not the way that anyone thinks about law anymore, except apparently Justice Gorsuch. And the dissent's main point was that experts should be making the sort of policy judgments inherent in the construction of regulatory statutes, and that, in my view, this was one of Chevron's biggest problems, though, because the problem with Chevron was some courts pretended at least to be so deferential that they never engaged with whether the agency's action makes sense in light of the statute. These picky issues, but even today, picky issues of statutory interpretation, to me, are really beside the point. The point ought to be whether the agency's action makes sense in light of social welfare, because that's what government's all about, is advancing the welfare of society. Now, I also want to say that one way that agencies will avoid the effects of Loper-Bright is to channel their decisions into the arbitrary capricious standard. Most agency action really could be reviewed under arbitrary capricious review rather than the Chevron standard. And the Supreme Court actually never gave a good explanation for when arbitrary capricious applies and when Chevron applies. They tried a couple times, but none of them really made sense. And in 2021, the court made an important decision basically reaffirming that review of policy decisions under arbitrary capricious is still very differential. So that seems to me to be a very important limit on whether Loper-Bright will have any significant effects. Now, there's also the fact that the court has now remanded about a dozen cases to the courts of appeals for reconsideration in light of Loper-Bright, 9 of them a couple days after the Loper-Bright opinion was released, and then a few more at the beginning of this term of the Supreme Court. And if the government continues to win those cases, we'll see that Loper-Bright is, as I predict, pretty much a nothing burger. But if the government loses a substantial number of those cases, then I'll be wrong and I'll confess error in my next paper about this. Now, the other thing that Craig mentioned is that Loper-Bright talked about Skidmore. Now, Skidmore was the form of deference that predated Chevron. But if you read the cases that the court decided in the years right before Chevron, they were basically already saying it, and they were already relying on these pre-APA cases to say it. So the Supreme Court in Loper-Bright said in Skidmore that the court explained that the interpretation and opinions of the relevant agency made in pursuance of official duty and based on specialized experience constitute a body of experience and informed judgment to which courts and litigants could properly resort for guidance, even on legal questions. And they said more of that. I won't bore you with this big, long one. Anyone wants this, they can send me an email. And I know, it's easy these days to be looking at your phone or your computer and doing something else while someone's speaking. And I just say, if you're doing that, go to jackbierman.com and buy my latest book on Abraham Lincoln. But that's a plug. But I think that reviving Skidmore basically is what I call snatching defeat from the jaws of victory for the anti-deference forces. And I'll give the example that I'll give. I wasn't aware of the tipped workers decision of the Fifth Circuit, which I'm in the middle of revising my textbook, so I'll put that one in there. But I have another one, the Mayfield decision. I already talked about that. I'm going to go ahead to the Mayfield decision. So the Mayfield decision is a case about the Department of Labor. Now, it wasn't a Trump appointee that wrote the opinion. It was a pre-Trump, I think a George W. Bush appointee, so maybe that's going to be a dividing line on this. But this was a challenge to the Department of Labor's minimum salary requirement for the Fair Labor Standards Act executive, administrative, or professional employee exemption. That is, salaried workers generally are not required to get overtime. But the Department of Labor has always prescribed a minimum salary they have to get, even though salary is not mentioned in the statute at all. It just says, as such terms, executive, administrative, or professional, as such terms are defined and delimited from time to time by regulations of the Secretary. So can minimum salary be justified under that power? Well, first the Fifth Circuit rejected applying the major questions doctrine to say they couldn't expand it to require a salary, and that just shows the only reason is it wasn't major enough. And what's major enough, we don't know. It's just a very discretionary decision that the Supreme Court hasn't defined. But and the court said that Loper-Bright means we must independently identify and respect these delegations of authority and police the outer statutory boundaries of these delegations and ensure that the agencies exercise their discretion consistent with the APA. I would say that's about 10 degrees different from Chevron. It's different. You can't say Chevron anymore, but you're saying very little difference. And the court then found that the best reading of the text supported the labor's position. Okay, so all well and good sounds like Loper-Bright. But then the court went on to talk about Skidmore. And they questioned whether Skidmore and Loper-Bright can really survive together. And Craig's shaking his head no, but there's so many Supreme Court doctrines that seem to be totally inconsistent with each other and survive that I don't see any reason to think that they're going to get rid of Skidmore. Obviously, they couldn't get enough justices on the Supreme Court to disavow Skidmore, and with the 6-member conservative majority, if they couldn't do it now, they're not likely to be able to do it in the near future. And the court said in this Mayfield case that if Skidmore deference does any work, it applies here because the Department of Labor has been doing this for 80 years. They've been consistent about it. Congress has amended the Fair Labor Standards Act numerous times without taking away this power. Those are the traditional things that you defer to agencies on when they act consistently over a long period of time. And one of the things that not having something like Chevron does to legislatures is it makes them be much less able to rely on court decisions, and especially if Justice Gorsuch's view of precedent takes over, where the court could have the same view of what a statute means for 70, 80, 90 years. The legislature, as you all know, leave it alone at that point, and then suddenly they change their mind, and you think, well, they just pulled the rug out from under us as legislators, which is not very good policy. So let me go back to what it may mean for, I'm trying to figure out, I have one last slide about, okay, so the future without Chevron. So first of all, will they actually defer under Skidmore? Second of all, with President Trump coming back into office, maybe the conservatives on the court will figure out another way to defer, the way they figured out how to defer under President Reagan. Because, of course, as we know from observing the Supreme Court, they vote on party lines almost as often as legislators do. But more seriously, less deference, if they really do defer less, that may moderate the Trump administration, because it moderates the ability of the government to lurch from one extreme to the other. And because judicial review tends to keep things closer to the middle. And I'm not going to make any prediction because, unfortunately, I'm nowhere near as good a predictor as Karnak the Magnificent, which was my favorite Johnny Carson skit back when I was a child. So I'll leave that to all of us to discover over the next 20 or 30 years. Thank you.
All right, Jack, you done?
I'm done. Thank you. Yeah, I said says thank you. Thank you. But again, jackbierman.com, my new book or my old book.
Okay, thank you so much, Jack. And now we'll hear from Michelle Long.
This over here. Hello, everybody. Thank you for the invitation to be here today. Thank you for the introduction, Representative Carter. My name is Michelle Long. I am here today from KFF, what you may remember as being called as the Kaiser Family Foundation. I'm here to talk about the implications of overturning Chevron doctrine on health policy, particularly on patient and consumer protections. So I think we've heard from both of you all how big of a deal actually is this. I think the jury is still out on that, but what we know is that so far there have been hundreds of lawsuits filed since Chevron has been overturned, with litigants seeking to take advantage of this new regulatory or legal framework landscape that we're in. As that applies to health policy, there have been a number of these lawsuits so far that cited overturning of Chevron deference. Those include lawsuits related to regulations coming out of HHS, related to Medicare payments and hospital reimbursements, litigation that has been filed in response to FDA regulations related to reclassifying laboratory-produced tests as medical devices, and then more recent and newer regulations out of the Biden administration related to FTC regulations banning non-compete clauses and employment contracts, which certainly has implications for hospital workers, among other workers, and HHS new regulations related to protections for transgender folks. But I'm here specifically to talk to you all. I think you're interested to hear about insurance regulations. And so I want to focus on first a couple of topics that I think are likely to come up as we roll into the next Trump administration, the next Congress, that I think will be revisited. First is access to plans that are alternatives to ACA compliant plans. Certainly that was an issue in the first Trump administration, with the administration aiming to expand access to these types of plans that, while they do offer less comprehensive coverage than an ACA compliant plan, they do tend to have lower premiums. And a goal of President Trump's executive order was to expand access to different choices to individuals. So those Trump regulations that were issued in 2018, what they did was they expanded the duration and renewability of short-term health plans. So short-term health plans were, I believe, designed to provide temporary coverage during a gap in coverage, say when you're changing jobs. And the Obama administration had limited the duration of those plans to less than 3 months. So the 2018 Trump administration regulations expanded those to effectively allow people to stay enrolled in these plans up to 3 years at the discretion of the issuer, of course. And noteworthy here that, of course, short-term plans are not required to follow any of the ACA regulations with regards to consumer protections, including coverage for pre-existing conditions. guaranteed issue, and a number of others. So that regulation was challenged and eventually upheld by the DC Circuit Court. In that case, Chevron deference was applied in that case. And in 2024, just earlier this year in the spring, the Biden administration issued different regulations, rolling back those expansions of duration to effectively up to 4 months of coverage in an effort to protect consumers from unexpected financial risk or financial loss when they do get sick or injured. And this regulation is being challenged. There's actually a number of lawsuits, but I want to focus on one in particular, the most recent one that challenges the entire rule, which also has regulations related to indemnity plans, which I don't have time to get into. But that latest lawsuit does also cite the overturning of Chevron deference in its arguments. So I think certainly we're in a new legal landscape, and the question is, will the Biden administration regulations be overturned? There's not time, if they are, for an appeal, and certainly I think when the Trump administration comes in, I do not think they will have an appetite to defend those. In fact, they will probably come in with issuing new regulations again, expanding access to these types of plans. But there is, of course, a state role here for states that are looking to fill in some of these regulatory gaps. If this does happen, 15 states have already elected to either prohibit the sale of short-term plans in those states, or provide or require them to provide more comprehensive coverage, such as requiring coverage for people with pre-existing conditions and benefit coverage requirements. And then sort of along those same lines of expanding other types of health plans as association health plans. That was another goal of the Trump administration, was to make association health plans more accessible for small employers, also for self-employed individuals. Traditionally, employers could, with a common interest, for example, could band together and leverage the purchasing power that a large group plan would have to purchase coverage for their employees. ERISA gives the Department of Labor and states some regulatory authority over these types of plans. And certainly there are more consumer protections in association health plans than there are for short-term plans. For example, they are required to cover the 10 categories of essential health benefits, apply community rating, as they are subject to the individual and small group market regulations under the ACA. The Trump regulations loosened those standards of what qualifies as an employer and allowed more association health plans to be qualified as large group plans, thereby subjecting them to fewer Affordable Care Act requirements. Those regulations hadn't taken effect, and they were challenged in the DC District Court in 2019, largely invalidated this regulation. Also applying Chevron deference, but coming to a different outcome than the judge in the short-term plan case, and determined that the agency's interpretation of ERISA's standard for what constitutes an employer was not a reasonable interpretation of that statute. Trump appealed. By the time that happened, though, the Biden administration was coming into office, and then, of course, rescinded that rule this spring. And so some of the implications I want to talk about here for consumers is the CBO recently released some data showing that if not specific to the administration, but if the administration were to come back in and try to expand access to these association health plans again, CBO estimates that about 600,000 individuals would get coverage under an association health plan, but only 120,000 of those who are currently uninsured. So it's not insignificant. There are folks out there who don't have any insurance coverage who might be able to gain insurance under this regulatory scheme. But again, more people would actually be leaving insurance plans, which could lead to some ACA compliant marketplace instability. CBO also estimated this would result in a slight increase in federal spending. So the question with both of these types of health plans, will the Trump pursue them again? Every indication points to yes. But will the outcome be different in this new legal landscape? We'll have to see. Will there be a sort of double-edged sword effect? I think colleagues here discussed that briefly. Just because an outcome was made in favor of an agency in 2018 or 2019, that might not be the case this time. And what might end up happening is that courts are left to define terms that are ambiguous in statute, such as what is a short-term plan? We know it's exempt from, it's not considered an individual health plan that can be regulated, but what does it mean for the duration of them? Same goes for the definition of an employer. And of course, obviously, as we've learned already, what court a case ends up in obviously will be a factor in the outcome. I've only got a few minutes left, so I do want to focus on a couple of other issues that we're watching in terms of health insurance regulation. And I want to talk about this one as it relates to scientific and medical expertise when it comes to rulemaking. Obviously, I think probably many people would agree that when it comes to expertise needed to define what an employer is, maybe a little bit less so than making clinical recommendations. So I want to talk a little bit about regulations related to covering preventive services, which of course is part of the Affordable Care Act. They rely on a few different expert bodies to make recommendations, clinical recommendations for preventive services, ranging everything from screenings to counseling, immunizations, services specifically for women and pregnant women, services for children. Research has shown that when these types of services are required to be covered without cost sharing is key, it does tend to increase their utilization. A lot of these services are very low cost for health plans to provide and can lead to reduced costly conditions in the future. There obviously have been multiple legal challenges. The ACA certainly has been subject to somewhere in the neighborhood of 2,000 legal challenges since 2010. But I want to focus today on Braidwood versus Becerra, which has been in the news a lot for the past little while. Could be headed to SCOTUS as the Biden administration has petitioned them to take a look at the Fifth Circuit's decision that that's providing relief specifically to the plaintiffs in the case, challenging those coverage requirements, in particular related to the requirements that plans cover preventive medications for HIV called PrEP. So what's next is the Trump administration will be unlikely to defend this case. However, a state could join. That has happened in the past, and a state could certainly join to defend the policy. But absent Chevron deference, could those requirements end up being invalidated nationwide? It's certainly a possibility. And again, here at issue is in the past several decades, agencies have been deferred to because they typically have the subject matter expertise to be able to issue guidance. In this case, we're talking about the U.S. Preventive Services Task Force, HRSA, a couple of others. This is important because these regulations change continuously. These expert bodies are looking at they're looking at the medical research, they're looking at the science continuously. They have the expertise to be able to update these as needed. I was giving an example earlier here about preventive breast cancer screenings. Those change. They've been changing the past couple of years. Does the woman need to be 40 to have a breast cancer screening, or should she be 45? Those are things that are continuously changing. And with probably increased burden on Congress, as well as certainly the judicial system, to interpret statute, do they have the appropriate clinical expertise or subject matter expertise for cases like this? I'm going to wrap up with just a couple other policy areas to keep an eye on. The No Surprises Act, which limits out-of-network billing for certain healthcare services. There has been an onslaught of litigation, and including a recent win in the Fifth Circuit for the administration related to how qualified payment amounts are calculated, that did cite Chevron. So this could signal actually a new, in this new legal landscape might be a little bit more nuanced than we think. We wouldn't expect a ruling out of the Fifth Circuit, I don't think, to favor agency regulation in this case. Every year, HHS issues its Notice of Benefit and Payment Parameters, which provide updates to requirements and interpretations of items in the Affordable Care Act that are not directly addressed, such as updating out-of-pocket maximums, risk adjustment calculations, network adequacy standards, and many others. The 2026 payment notice was just recently issued, so something else to watch there. And then as we think about what's on the horizon, I think one thing that's really big on our minds is the use of artificial intelligence in healthcare, and including its use by health plans. Can Congress anticipate every single new development that's going to come down the pipeline over the decades? No. But will it have to try harder to do that? Yes. So I would give as an example ERISA, written in 1974. Could they have anticipated how AI was going to develop, that plans would begin using it in some cases in coverage determinations, including denying coverage? Maybe a few, probably not many though. And so there's a lot more, I think, on the horizon in terms of development, artificial intelligence, as well as technology that I think we'll have to continue to watch. I wanted to go back to one thing that I missed regarding preventive services. I did want to mention the role for states. Certainly states can and have attempted to fill in gaps or prepare for the requirement that plans cover preventive services to go away. And in fact, many states actually do already require coverage of preventive services and related to subject matter expertise. A lot of them do rely on the U.S. Preventive Services Task Force requiring coverage of contraception, tobacco cessation products, and others. So there is still a role for states there, although I think we're discussing now what the implications of overturning Chevron might be even for state regulations as we go, as we go forward. So I will end there and pass it off.
Okay,
Thank you.
Thank you, Michelle. And our final panelist today is Greg Serio. Please.
Thank you, Madam Chair. Good afternoon, everyone. I'm going to take this from a slightly different perspective at the state level. As a former insurance regulator, 10 years at the New York Insurance Department. But for those of you who know me, may not know that prior to that, I spent 12 years with the New York State Senate and the Insurance Committee, and one of our founders at NCOIL, Senator Dunn, as his legislative counsel. So I found myself in kind of a weird vortex along the way of getting substantial deference from bills that I actually wrote from the Senate side, and then as a regulator, and getting substantial deference to interpret those statutes in a way that I thought necessary and appropriate as a regulator. So when Loper came about, it really took me back to those places. And so in preparing for today, and I appreciate the invitation to be here, I went back to some of the Court of Appeals cases in New York, in a state court basis, the New York Court of Appeals being the highest court in New York, to see how did this actually work in practice, and how was I impacted by the notion of deference as a regulator. How did what I wrote on behalf of my principals actually contribute to the notion of deference in the body of law with respect to deference to the regulatory body? And one of the things I concluded, and I'll give you some unscientific observation and then give you some recommendations, since we have an audience of legislators here. But one of my conclusions was that I think the Loper repeal of Chevron may actually mean a rebirth of state legislation and not necessarily state regulation. And I'll tell you why. First of all, the Loper decision, Chevron before that, Skidmore, all of those cases all start at the same place. And they start at the same place being the statute, whatever statute the regs are coming from, whatever statute where the legislature is expressing their intent, and then how the regulator addresses it in regulation when it's handed off to us after our governor has signed the bill into law. And the Loper decision is actually as much a message to legislators as it is to regulators, as it is what regulators can and cannot do. And by the way, we regulators will go as far as everybody will allow us to go. Okay? In the New York case in 1992 called Boreali versus the Commissioner of Health, the health department didn't even need a statute. They just went ahead and did an indoor smoking prohibition regulation, which was appropriately overturned and thrown out by the Court of Appeal. Said, well, you can't possibly just do regulations without some form of statutory basis. But how far do you go from there then remains to be seen. And so the first lesson in the Loper-Bright case to the legislators is that ambiguity is the absolute enemy. Now, over time, spending 12 years with the New York legislature before spending 10 years with the insurance department, we don't always have the luxury to write what we mean and write what we want. And oftentimes things are complex enough that we need to leave this to the regulators. And so what we end up doing from the legislative side, that we actually enforce this notion that the regulators are, in fact, the experts who round out the details of these broad policy statements. And then, of course, everybody's surprised to find out that the court is actually giving some level of deference to those we've already deigned to be the experts. And they're regulatory, we've written hundreds of pages of regulation based upon a 2-page bill. And where do you think that conversation goes ultimately when you have a 2-page bill and a 100-page regulation? You're already down the rabbit hole of questions of regulatory overreach. And this happened to me, it wasn't necessarily a 2-page bill or 2-page law, but rather a law that had been around for a long time. It's the New York no-fault statute, which goes back to 1973 or so. And in one of the seminal cases on regulatory power is a case called In Re Medical Society versus Serio. I like to refer to it as Medical Society versus me, because that's what it was after. And it was a 3-year slugfest between the insurance department and the medical society, who, parenthetically, and there's no aspersions upon anyone, had joined forces with the trial lawyers in suing the insurance department. Anytime you get the medical society and the trial lawyers together, you have accomplished something, because they never are on the same page of an argument. But when you're putting out no-fault regulations, they now had a common enemy in the superintendent of insurance. The first go-around in Medical Society versus Serio, we lost that case because we failed to follow the State Administrative Procedure Act, which is a big part of the Loper decision. It's a statutory analysis of the federal APA, and every state had its own version of an Administrative Procedure Act. And so they gonged us on that and said, you have to go back and revisit your regulatory process. Trial lawyers in the medical society, they succeed. I go back to the department and said, we have to come up with another approach to this. We came back out of it, and the Court of Appeals ultimately decided that, yes, you had followed substantially the State Administrative Procedure Act, which is a statutory embodiment that all of you have passed in your houses and your predecessors have passed, And that becomes the foundation of any analysis about regulatory discretion. And the courts then, or the Court in the Court of Appeals then said that in New York, being a state affording broad discretion to the regulator, but not an unlimited discretion, to Jack's point earlier, the Court of Appeals said, no, you have broad discretion to implement these regulations based upon the intent and of the legislature and the language in the law, except for arbitrary, capricious, unreasonable, and irrational. My rationality was often called into question, but my capriciousness was not. So what you have here, you already have a construct. And I would say in the state court insurance world, we have a construct that is very well developed. We have a muscle memory, and we have principles that have already been established at the state court level that would limit the impact of LOPR at the state court level. Why? Because we do insurance regulation at the state level. Our courts, generally, I didn't do a survey of it, but I did review the New York cases, we are good at it. Our state courts are really good at understanding insurance law, understanding insurance regulation, and then interpreting them and the actions we take within them to decide if we have stepped over the line or not. And by the way, the we being not just the regulators, but also the legislators. And so we have a very different place where we start the analysis from as compared to the federal government, which will work on 8 million different things, and the federal court will work on 8 million different issues. But because the states are the province of insurance regulation, it is a well-earned reputation and respect for actually knowing how this works. And so you don't see that fisticuffs and that tension at the state level because, I can speak for the Court of Appeals in New York, it is an excellent insurance bench. And so even when they do go into the substantive questions, they are an excellent bench for being able to discern complicated questions of insurance law. At the same time, and for those of my friends here in New York, we call the third department of the appellate division home court advantage because the regulations are done in Albany. You go to an Albany court, we know all the judges in Albany, and somehow the track record of the insurance department or DFS is exceptional when we take our appeals to the third department because it's in Albany. And this is how this goes. I'm not sure if there's a scientific proof of home court advantage, but I can tell you because you're dealing not just with the administrative state, but the legislative state and the judicial state all in one place, and where you don't have forum shopping to federal courts as much as you might on certain other issues. For the most part, those parts of insurance regulation that's done by the states, issues are litigated in the state courts, and we've been doing that for a very long time and with some degree of success. So I'm not sure I'd go so far as to call it a nothing burger, but I think you have to approach LOPR in a more measured analysis in terms of whether this is going to undo what we've done up to this point in time with respect to state-based insurance regulation. But that then brings me back again to state legislation. And it brings me back to this other issue of, okay, you have your state statute, you have your regulator do the regulations, promulgating regulations in compliance and conformance with the legislation, then what? Now, in the Medical Society versus Serio case, the Court of Appeals actually spoke about the notion that the legislature did not revisit the issue that was addressed by the statute, the 1973 no-fault statute. Even though we did lots of fine-tuning along the way, the Court of Appeals actually said the legislature must be pretty comfortable with this because it hasn't decided to take on a de novo approach to reconstructing auto regulation in New York. That became proof to the court that the legislature is actually pretty comfortable with how the regulators manage the auto insurance marketplace. And that's a really telling observation. So you are being judged not just by what you do, but what you don't do. Now, it doesn't give me authority, like in the Boreali case, to just go off and write regulations, for my own pleasure. But the fact is that I had an original enacting bill, I wrote a series of regulations pertaining to that, the court takes that as a sign that the legislature and the regulatory body are in sync with one another. They're in alignment about where they believe that law is being implemented. And that's an important observation. So I dug through Loper for the perspective of how does this actually work in the state-based insurance regulatory system. And that, and I do commend Medical Society versus Serio, the whole package. I'm not as good of a seller as Jack is, but it's all free. You get the court cases free, so you don't have to pay anything for it. But I think if you look at those cases from the trial level to the appellate division to the Court of Appeals, you will find that string of logic that you're looking for to put Loper into context for where you are. And I think you'll find that there's a slightly different experience at the state level than there has been perhaps at the federal level, that you will also revisit your own State Administrative Procedure Act. You will look at the body of case law that has been developed under your own Administrative Procedure Act, and then you will decide both that constitutional question of the separation of powers and whether you've had statutory compliance with your Administrative Procedure Act. So let me do this so that we can have time for questions. So the recommendations I have for you is this. As you wait to see how Loper pans out at the state level, and none of us know, frankly, I could be a lawyer on this tomorrow and say, of course Loper has to apply to the states. This is what we get paid for. But in the meantime, what are those things that legislators can do for the rebirth of state legislation? So the first thing would be, go to your State Administrative Procedure Act. Understand what it does, because you will have a statutory analysis. We have lost cases by not complying with the State Administrative Procedure Act, as I mentioned. And so that is a place that you want to know what has been the state experience on your regulators following the State Administrative Procedure Act. Did they give notice? Did they give time for comment? Did they hold a hearing? Did they publish the material departures in the comments that they got from interested parties and then make amendments to the regulation appropriately? That's where you're going to get challenges to regulatory activity, is on those technical nuances of your individual State Administrative Procedure Acts. The next thing I would say is use your legislative oversight powers more assertively. Words I would never have said when I was superintendent. But I'm saying use them. One of the best things that I found in the 12 years I worked for the New York legislature was the legislative oversight powers. All right? You call the department in, it's okay, we have this regulation, what's your, how are you approaching this? Or we've been hearing a lot of things about you going off the deep end on these regs, and then how do you follow up on your oversight responsibility? Like I said earlier, ambiguity is the enemy. Right? Comprehensive statutes. That's why we have model acts here at the NAIC, model regs at the NAIC. You have that interaction on the model regs and on the model acts. We, behind me, do it all the time when we say that's overreaching. Can you do it this way? How do you apply those model acts to your individual state setups? Critically, as a practicing lawyer this is the first place I go when I have a statutory analysis. I go to what we call, and I'm assuming everybody has some tight name for this, go to the bill jacket. Go back to the origins of the statute. The most effective way to remind people of the intent of a statute that you may not remember, you may not even have been around when it was done, is by going back to the bill jacket where everybody has written a letter into the governor saying what the purpose of this statute is. And then you see the departures on the regulatory side and say, wait a second, we're going to drag you back to the origins of this bill. Very effective. I find a lot of lawyers don't do that. I'll finish up. Two more suggestions to you.
Okay.
Okay. The next issue is sunsets. If you use sunsets on bills, they become automatic rejoinders, if you will, on the statutes that you put in place. Some of the people in this room will know I had a boss back in the Senate days who loved sunsets. He had a slightly different purpose for using them, but I will tell you as a legislative tool, they're incredibly worthwhile because it forces everybody back to the table on the topic. And if you have a reg that has gone off the deep end, when that 5-year sunset comes up, guess what's going to happen? You're going to write a more comprehensive bill, and you're going to start to guardrail what the powers of the regulator can be. So, Madam Chair, thank you very much. I take your stage directions quite well, so I appreciate your
Thank
time.
you, Greg, and thank you, panelists. I mean, this was great. But we're going to open it up to the legislators and see if they have questions. Okay, starting off, Representative Matt Lehman.
All right, thank you, Madam Chair. Thank you. You guys all did a fantastic job. A lot of information. You reminded me why I did not go to law school. A couple of things is with all of this happening, what's the next conflict? Because as I hear this, I've heard said, fill the gap, go in and find out where these regulatory issues are. The courts, the ambiguity of the Chevron case was, we see it different than the regulators do, but we have to defer to the regulators. That's been overturned. So now you have the courts who can say, we don't agree with the regulators, here's our decision. Now we're going to come in and say, now we want to fill the gap and say, no, that should not be your decision, it should be this statutorily. Are we on track for a conflict with the judicial branch in any of this? Because we're willing to step in and fill the gap, but we're also now maybe picking a fight with another branch of government. Does that make sense?
Yeah, I would say the next step is whether the court reinvigorates the non-delegation doctrine. And they just took a case this week about whether it's appropriate for Congress to delegate to the FCC the authority to set the universal service fees that go to carriers. And there's been an argument that's been brewing in this current court for the last several years that says that they're going to cut back on Congress's ability to delegate authority to agencies. So no matter what the legislature does, if the court says you can't do it, then you can't do it.
I'll go one step further on that. In the Medical Society case, there was actually an entire section on the delegation of authority to the private sector. And you may see some of that occurring, particularly in the new administration, where you have what may be perceived as a delegation to the private sector, and the court had to go through an entire analysis about whether my regulations actually was an inappropriate delegation of authority to carriers to set standards on their own. The court ultimately determined that it was not a delegation to the industry.
Thank you.
I'll just add to that, hopefully not too tangentially. When it comes to states filling in some of the gaps that might be left from federal regulation as it pertains to health insurance, I'll use the example of benefit requirements and health plans. Certainly, as I mentioned, a lot of states are already doing this. And certainly more will probably look at fertility coverage of fertility services is a big one that's getting a lot of attention right now, and that we continue to see states taking an interest in. The limitation there, of course, is that those state benefit requirements pertain to state regulated plans. We know that the majority of covered workers in the United States are enrolled in a self-funded plan that's sponsored or established by a private health insurer, and so those sorts of coverage requirements would not reach those folks.
Thank you. Next, Representative Ellen Hefner.
Thank you, Madam Chair. Thank you for your presentation. This is a lot of information that got this big lump in my tummy right now because of this, your quotes about ambiguity is the enemy, and with the amount of work that I've done with disability policy, and then leaving this all open for interpretation to a new judge or a agency that hires workforce shortages, taking on how far we've come with disability and a good life. And so my only comment is even though we can still go back to the courts, if we don't care for something that an agency does, we're still relying on if you don't have a history of what it is, we may be pushed back. So the comment is only, it's a lot of concern that I know of, and even legislatively, getting new legislators in there too, who don't know disability policy history and how far we've come. So it was a decision that I wasn't really looking forward to. Thank you.
Thank you. Representative Stephen Meskers.
Thank you. I'll just echo the comment in relation to the Americans with Disabilities Act, just in support of my colleague. But my question is, I've never been left more confused about where we stand in relation to the law. And if I go to the ends of the table on either deference and or statutory authority, what would you guess is the time frame that will have clarity on the importance of the Chevron decision? Because what I heard today was it's either super important or marginally relevant. So I'm trying to figure out what's the timeline for the decision.
Sure. So let me start at this end of the table, I suppose. I'm not sure that I disagree with Jack as much as he might think that I disagree with him. I think on the history, which I've studied really quite a lot, people have disagreed about the scope of deference and what it means since day one, from the very beginning until the very now. They've disagreed with under this formulation of words, under this formulation of words. Chevron, the reason Chevron gets the marquee billing is because it was thought to formalize and set out a framework that a lot of courts could do, was thought to represent a gesture, a step in a direction. Not a lot of clarity, exactly how does it work? And then it survived for 40 years when people like ourselves and people like lawyers and courts fought about it. That means they disagreed about it. That meant it was unclear. And so different people have different impressions. And that fight all happened in this terrain, if I could put it that kind of a way. And the Loper-Bright opinion in overruling Chevron, one of the reasons they thought Chevron would never return it, because you do whatever you want within Chevron. But they couldn't do whatever they wanted. They overturned Chevron. That's like a new message. It's not going to be clearer in the future than it was in the past. It wasn't that much clearer under Chevron than it was the days before. But this message, I think, really is ambiguity is the enemy. This message is legislators need to do more. Agencies need to do more. Another different version is agencies really need to dig into their own evidence and show their expertise, I have been told on panels, then they will win expertise. I'm not sure if you're the EPA or the FTC or the CFPB, that's, go do your homework harder. I'm not sure that's really exactly the message. But so that's what I would say is that I think, in terms of what clarity means looking forward, it's not going to be much clearer than it was before. Skidmore suggests it would be every bit as unclear, if not more unclear. One of the reasons Scalia hated Skidmore was he thought it was the old totality of the circumstances test. But I don't want to be naive about how clear things were under the Chevron regime, but I certainly think this represents a reset button of sorts. It is at least a rhetorical, at least a symbolic message that all the fights we've been having before about ambiguities and the expectations legislators had about what they could accomplish by sending out delegations of authority, sometimes not is the clear, how many not? I think that's left to be determined. But I think, we should expect at least another 40 years of confusion. There was 40 years of confusion under Chevron. I think the new confusion, but it'll happen in a different terrain. It'll happen in a different neighborhood than with the before.
Chevron was a 40-year degradation until, Chief Justice Roberts, with a very angry pen, said, "We're done with this conversation." But that's only part of this, is that then you have to go back and put it into context. And so what you may have in that context regarding fishing regulations may not be the same when it comes to the ADA, or something that they may deign to be far more critical or far more deserving of more regulatory deference because of the specialty or the complex nature of that issue.
I just have a one-word answer to your question: never. The Supreme Court never does anything that's clear. And so why would they be clear on this? I mean, once in a while they come up with something that seems clear and they stick to it. But just the fact that, like, for example, the most famous case in the history of American law, Marbury versus Madison, could be cited for what it says and what it's opposite of what it says. So I think the answer really is that it really depends on the politics of the day in Congress, and that's always been the case. There's never been clarity under Chevron. There wasn't clarity before Chevron. There won't be clarity under Loper-Bright. And I looked at the decision the two decisions that we were talking about from the Fifth Circuit, they're written by the same judge. And they seem to be somewhat in tension with each other. So I just don't, the idea of clarity in the law, what you all do is much more important than what courts do, because when you write a statute, those words are frozen. And they may not be completely clear, they might not be comprehensive, they may be somewhat ambiguous, but you can't just disavow them the way that the courts disavow what they said in prior opinions, or twist what they said in prior opinions to give the same words their opposite meanings.
Thank you.
Okay, thank you, everyone, for participating. If you have additional questions for our panelists, please reach out to them. I would like to say, up next is the meeting on financial services and multi-line issues committee in this room at 3:30. We'll take a quick networking break and meet back here then. Thank you.
You were great.
That was great. Yes,